Hi, everybody. Today we are here to continue the Power of Attorney webinar series. And this webinar about Power of Attorney is what I called No Surprises Document Review, and talking about all of the surprises that can and do happen. I can assure you that a lot of the things I'm going to talk about here are things that your attorneys can't even tell you because they haven't experienced this, and because they write the documents, but many of them don't actually serve as that power of attorney or that person who has to show up at the hospital or the bank or anywhere else and become that advocate. So in this section, we're going to talk about how to avoid common issues with power of attorney documents by talking about all of this now instead of later to avoid surprises, making sure that your attorney adds this information into your documents when he or she creates them. And I'm also going to, on my website page where this video also resides, there will be sample documents that I have marked not for use so that you can see what these documents look like if you've never seen them, but know that they're different by state, and I'll talk more about that. I'm Pamela D Wilson. I am a caregiving expert, advocate, and speaker. For 20 years, I have served as a professional fiduciary, which is why I can talk about all of this and share this information in the roles of agent under medical power of attorney, financial power of attorney, guardian, conservator, personal representative of the estate, and the trustee. So please like this video, follow my YouTube channel, and please comment. Your comments actually help other people find these videos, and they do make a difference. You can also go to my website, PamelaDWilson.com. You can find all 10 webinars in this Power of Attorney webinar series, along with links to a lot of the documents that I refer to in these webinars. And this webinar in particular has a lot of document links. So you're going to want to make sure that you go and visit that page. The link to that page is below in this YouTube video. So again, there's going to be sample documents of medical power of attorney, financial power of attorney, and a living will that are titled Not for Use. The reason that I'm including these is that many people have never seen what these documents look like. So if you're thinking about doing it, it's always good to know, like, well, what am I getting into? What is this going to look like when it's finished? Now, I'm mentioning this like multiple times, right? These documents are purposely out of date. They are not for you to copy. They are not for you to use because there have been a lot of recent updates, rules and regulations. Again, I'll include documents about these on the website page. And even more importantly, states have different rules. They have different regulations. So if you're doing documents, they should be particular to the state where you live and where you think you're going to pass away in, right? So again, we're using them for an outline. Again, try to avoid surprises about what you're going to come out of this thing, out of this webinar with, right? Come out of the attorney's office with, right? And so, but this will help you create a list of questions for yourself or for your aging parents to make sure that when the documents are drafted, you have every single issue that might possibly come up that you could think of, right, is in there. So I call this video, again, how to avoid these unexpected surprises. And really, I'm going to give you what I call my list of secrets that I have experienced, documents that had this information or didn't have this information over the past 20 years. So again, you can come out of here with a list, with a plan to go talk to your attorney about this. Okay, so again, just remember there's 10 webinars in this series. The goal is so that you're well informed, you know what these documents are, you can have a discussion with your attorney, you can have discussions with your agents, again, so that you're prepared. You don't have to worry about it. And the information in these webinars really are things that most people don't know to tell you, or that they don't have the experience to tell you. These are really the secrets about things that you want to prepare for so that they don't happen to you. So what are we going to talk about? We're going to talk about medical errors. They do happen. We're going to talk about why you should have a provision in there for guardian or conservator. We're going to talk about why you may not want to appoint co-anything, co-agent, co-guardian, co-conservator. That can be really complicated if the people that you appoint do not agree. Can actually be a nightmare. We're going to talk about why it's important to have provisions for successors if the person that you appoint dies before you. Maybe they're going through life situations at the time that you need them to act and they can't do it. You never want to have a document that doesn't have a backup plan in it. We're going to also talk about medical permissions and who can and who can't have information. Same thing on the financial end, okay? We're going to talk about provisions for care management. We're going to talk about working with banks and financial institutions. What do you do with all these digital assets? What about all these accounts you have on the internet for like podcast accounts and your Amazon account and Facebook and all of that? Living wills, and then we're going to talk about document mobility is which like if you move to another state, or does this apply if you're in another state, all of that. So we're going to kind of just go down this checklist one at a time. So medical errors. I have been doing this for 20 years, and I can tell you none of these are ever expected, but they happen, and they always happen when you don't plan for them. So there's a couple of things. There's a document called a MOST form, medical order, scope of treatment. There's also one called POLST, so MOST and POLST. There will be a MOST form on the page on my website, PamelaDWilson.com, in the Power of Attorney webinar series with this module that you can download and look at. You can also get a copy from your doctor. Or sometimes people will use a DNR form or a 5 wishes. Really, the MOST is probably the best one, provided that you have a living will. Okay, so again, if you haven't seen it, there's going to be a copy in the course materials. It's usually printed or provided on this bright lime green paper, so it's easy to find, right? You can get a copy of this form from your doctor's office, and your doctor will actually fill it out with you, right? Okay, so I'm going to go through all the questions on the form, because people get these forms and they look at the questions and they're like, I don't know, why would I answer yes or no? Or what should I put on here? Okay, so you want to be very thoughtful when you are completing this form, because if you create the form and you put it on file and you later disagree, or you're unconscious and your power of attorney knows you would have disagreed, but it's not in writing, the doctors are going to argue with you. And I'll share a story about this. I know this from many unpleasant experiences. Also, if at any point you change your mind, make sure that you do a new document, and make sure that you destroy the previous document, and on the document, the new one, write replaces prior document dated June 21st, 2020 or whatever. Because what happens is these forms get into medical record systems, and the medical record systems always don't talk to each other, and they may not transfer within your state or across states. And so you may get to the hospital and you did a MOST form yesterday, but the one in there is from 5 years ago, and the one from yesterday isn't on file, and you don't have a copy. You know which one they're going to pay attention to? The one from 5 years ago. So realize that hospitals, doctors scan these into their medical record systems, and right now in the United States, medical record systems are not, the term that the professionals use is interoperable. There's very little interoperability between medical record systems and healthcare systems right now in the United States. So it's really up to you to make sure this stuff is accurate, right? Okay, so Section A, do you want CPR? Cardiopulmonary resuscitation, yes or no? There's no gray area here. It's yes or it's no. So why would you want to say yes and why would you want to say no? If you're young, if you're 25 years old and you get electrocuted, right? You probably want CPR because you're pretty healthy and you're going to recover. If you're 90 years old and you got a lot of health issues, you may not want CPR. And why is that? On this page on my website, there is an interview with Dr. Michael Gordon about the risks of CPR. He was a palliative care physician, and his story is actually very interesting. But he talks about the risks to older people that include broken ribs, right? Ribs that puncture your lungs. If you have a lot of health problems and your heart stops and you stop breathing, which is the reason you would need CPR, it's unlikely that you're going to be better after you're brought back. than before. So if you know that your life is like just okay right now, and if your heart stops and you stop breathing, basically you're dead, right? You're asking to be brought back from the dead. If you're brought back from the dead and you have a lot of health problems, you're probably not going to be more physically able or more mentally able. Do you really want that? It's an important, important decision. So if you go to my website and you listen to that podcast with Dr. Michael Gordon, it's going to answer a lot of these questions that you might have about, do I put yes or do I put no? Section B on the most form is about medical interventions. This asks if you want to be sent to the hospital for full treatment. So let's say that 911 comes to your home and you say, yeah, I want CPR. So you're revived. Do you want to go to the hospital? So if you want to go to the hospital, but you want to avoid intensive care, which is where they're going to do everything they can to save you, right? Then you have to be careful how you select this one. And you would say, well, I want to go to the hospital, but I don't want intensive care. I only want comfort care. So what on earth is the difference, right? Okay, so intubation is where they put a tube down your throat because you can't breathe by yourself. Feeding tube, they put a feeding tube in your stomach because you can't eat. So how much of this being kept alive by machines do you want or don't want? Again, if you're 25 years old, you're probably going to survive. I can't guarantee that, but highly likely. But again, maybe not. And again, I'm going to reference that David Drummond Eat Cookies video. He didn't have any of these documents, but he fell off a retaining wall and injured himself to the point where he was quadriplegic. So things do happen. And so because of all the issues that I have seen in the past personally with medical errors and debating wishes with physicians, if I am that medical power of attorney, what I always did was I chose full treatment so that in that medical power of attorney document, it would say the agent under power of attorney has the decision to make these choices for me based on what he or she knows that I want, right? So unless I had a client on hospice, which meant they were never going to go to the hospital, I always kept the greater options, and I'll explain why in a minute. Because full treatment allows the agent under medical power of attorney or the guardian to make the decisions to withdraw mechanical life-saving treatment or to even change treatment based on your wishes, though. Okay, they're not, I don't make these choices because I think that's what should be done, right? I only make these choices because the principal in a power of attorney document has said, I do want or I do not want, and I'm very clear about this. Now, I'll tell you, the full intervention, doctors always don't like to see that checked with older people for some of the reasons I mentioned. So again, go back to listen to that Michael Gordon podcast. But also know that there's a lot of bias against care for older people in the healthcare system for reasons and the stories that I tell in many of these webinars, these 10 webinars. I tell many stories about things that happen, unexpected things that happen, things that you would never imagine that would happen that I can help you avoid, right? So the other critical thing to know is that these most forms or post forms or DNR forms are suspended if there is surgery. So here's another point where you want to be super, super, very, very clear with everybody. They're going to suspend it whether you want it suspended or not, okay? They're not going to give you this right because they could give you some anesthesia that causes your heart to stop, right? That, in a sense, is kind of a medical error or an unexpected complication, right? They don't want to let a person die just because, oh, we gave you a medication, your heart stopped, right? They're going to try to bring you back. Okay, but here's the deal. You have to know that your loved one can come out of this surgery on mechanical life-saving measures. So one thing that your loved one could say, or that you and your loved one could say together right before surgery when you're talking to the anesthesiologist or the physician, you can say, look, I understand that you have to suspend my DNR document, But what I'm telling you right now is that if for some reason my heart stops and I'm not breathing and I'm technically dead, and you cannot revive me after a minute or after 2 minutes, I want you to let me go. I do not want to come out of this on any kind of mechanical ventilation. Okay? Now, obviously, they have the choice to do that or not, but if you make it very clear, it's possible that they will follow your wishes. Okay? So you got to be very clear about this prior to every surgery so that there's no surprises. Section C on the most form is about artificial nutrition. What is that? This is another section where there can be huge, huge debates. And I'll share a story about this in a minute. But I always write information on the most form in these sections that can state like additional orders, ask agent under power of attorney. So artificial nutrition means that you cannot swallow or consume food, right? So they're going to put in a feeding tube or a TPN line or some kind of line, right, that gives you nutrition. So if you are in a medical condition where the only thing that is keeping you alive or prolonging your life is this artificial nutrition, would you want it? Because if you didn't have it, then you would just pass away on hospice care and die, right? This is the only thing that's keeping you alive. How much longer do you want to be kept alive? Days, weeks, possibly months until your body decides to shut down? It's another very serious thing to consider. And let me just share that story right now. So, and you may have heard this one before. So, client of mine, I was her guardian, doing great one day, fell, broke a hip. Next day in the hospital, has hip surgery. When she comes out of the surgery, she can't swallow because they intubate her, they put a tube down her throat. And on her most form, she had written no artificial nutrition, no feeding tube. And so I was debating with the doctor. I'm like, I understand this, but you know what? We didn't know you were going to injure her, and she's pretty healthy. She wants to live. So, you know, if for some reason she can't eat or drink in a couple of days, we do want a feeding tube so that we can have another type of intervention, which is called vital stem treatment, to help her regain her swallowing. And he really argued with me about this. But fortunately, my client recovered. She was able to swallow again. There were no issues. But I mean, these kind of crazy things happen, right? You never expect that there's going to be any kind of injury or anything during surgery that's going to contradict what you had written in a medical form, which is why you always want to put in the option, ask my agent under power of attorney if there is doubt. Section D on the most form, again, are boxes with names of people who were checked at the time this form was completed. So it could be the physician, could be the patient, could be the physician, the patient, and the agent under power of attorney. Then everybody signs this and dates it. You want to make sure that your doctor keeps the form. You get the green copy, right? Make copies of the green copy. Put it everywhere on file. If you go to the hospital, put it on file there. If you go to a nursing home, put it on file there. Make sure it's on file everywhere with the correct date. And in your home, you should put it on your refrigerator, because if 911 comes, that's the place where they're going to look for it, okay? And so that's important. So let's talk more about medical errors, because these do happen, okay? So what can happen is you want to have a most form or a pulsed form or a DNR or that 5 wishes in conjunction with a living will, because these forms are pretty short. They don't explain a lot about, well, if this happens, I would want this. They don't give you a lot of extra options, right? It's just like, yes or no, I do want this or I don't want that. Well, there's complicating circumstances in a lot of circumstances, as I've already explained, right? So in your separate legal document, which is your living will, you can include way more specific information about exactly what you want in life or death situations, or in unusual situations like a diagnosis of dementia or Alzheimer's or Parkinson's, okay? And so what I want to talk about is the crazy things that can happen, right? And there honestly are a lot of them. So I call these lessons learned, because of the breadth of experiences and the number of experiences, the number of clients I dealt with. I see or I have seen the situations that happen to like 1/2 of 1% of the population, right? And so if you're that 1/2 of 1% of the population that stuff always happens to, these are things you're going to want to be very, very clear about, okay? So again, medical errors and interventions. If you're that medical power of attorney, you also want to find ways to think about what the interventions might be, how to ask providers about what can be done in certain circumstances, because a lot of times providers will tell you what you need to know in that moment, right? And you may be saying, well, I want contingency A, I want contingency B, I want to know what happens here. You got to pull that out of them because they're rushed, they're in a hurry. They're only telling you what you need to know right now. And honestly, in that example that I shared a minute ago about the client who had her throat was injured because of the tube, right? That doctor had no idea that there is a therapy, occupational therapy called VitalStem out there, okay? Surgeons don't always know everything that exists. Sometimes care managers know more. Sometimes patients can know more. As medical power of attorney, if you've investigated these circumstances, you can know more. So you have to have the confidence and the advocacy skills to request very kindly and factually what physicians know and ask them to follow your request or the request that's in the document, even if they're disagreeing. You're the one, you also have to know this, right? You're the one that's going to be questioned if something goes wrong. Questioned by family members, attorneys, maybe the court if you're the guardian for a decision. So you've got to be very investigative, methodical, thorough in your actions and the steps and the decisions that you're going to make. Never let anybody, a doctor, a nurse, convince you to do something that you know the person you are responsible for would not want done or that you don't agree with. You gotta just have the oomph to say no, right? Because the decision really is yours, it's not theirs. And the decision is going to affect this person who is not their family member. It's just to them, I hate to say it, but it's just another patient, it's just another body. And so, again, if you're that person that falls into this 1/2 of 1% crazy things happen to me, make sure you do all this. So let's talk about another situation. And this is a recovery situation. But so I had a daughter who was power of attorney for her father. And he was in an accident and he was in a nursing home. And the nursing home just wasn't really taking care of him. They weren't giving him nutritious foods and not enough physical therapy and not enough of all these things. And the daughter really wanted to take him home because she knew she could provide better care. And they had the money to do this, right? But the physician at the nursing home and the nurses at the nursing home were like, we don't think you can do this. And so she contacted me. And at the time I had my care management agency called the Care Navigator. And she said, will you help me do this? And I'm like, absolutely, we'll help you do this. And she said, well, they're threatening me. They're saying that my doctor bill and my medical bill and my nursing home bill is not going to be reimbursed by insurance because I would be taking him out against medical advice. And I said, well, you have the right to do that, provided that you have a good plan so he doesn't immediately come back, because that's what they're worried about. They're worried about you taking him home and something happens and he shows back in the nursing home or the hospital in 3 or 4 days, right? Because they get financially penalized for that. So met with the daughter, went to the nursing home, met with her father, met with the nursing home staff, the nurses, the doctors. We had a full plan in for caregivers going into the home, doing exercises, making sure he got good nutrition and all of that. And it was actually very successful and he recovered fully. But again, if you are not skilled at doing this and you don't know how to do it and what services and what assistance is involved that you can access, you may just leave somebody in a nursing home to die, even if they're not getting good care. And I really don't recommend that. You can always move them to another nursing home. You can complain to the state. You can complain to the ombudsman. I hate to say it, but a lot of times, even the executive directors of these nursing homes don't know what's going on because patients and their family members do not complain enough. Okay? So next section, we're going to talk about provision in a power of attorney document for guardian or conservator and why. So this provision really is just like a checkoff. You want to make sure it's in your document. Including this provision in the document should be automatic by your attorney, but sometimes it's not. Again, if you're not using elder law, probate, or estate planning attorney, and you're using family law or somebody else, they are not going to know about this. So you want to make sure the document has a provision that says, if I, the principal, so the person who the document's for, ever need a guardian or a conservator, then my first choice is my agent. My second choice would be my successor agent, okay? So having that in the document avoids any later need to go to court to say, to have arguments about, well, who should be the guardian, who should be the conservator. It's already in the document. It's just again, it's a check off. You fill out a form. You say this person has appointed me. It's usually granted in the court, okay? Next one I want to talk about is why co-agents can be extremely complicated, actually can be a nightmare situation, okay? So while you think, well, it might be good to appoint two of my children so they can work together, or, a professional and another professional so they can work together. What you don't know is if these people really can work together, and if they have different philosophies about the way to make decisions and to go through the process of decision making and all of that. Because if there's any disagreement, it's going to be a nightmare for these two people. And they may both resign, right? And then you don't have a successor, and then where are you then, all right? Parents sometimes do this to avoid hurt feelings of their children if there are multiple children. Thought is, well, if I appoint my son and my daughter, there's going to be no hurt feelings. But let me tell you, there could be a lot of hurt feelings when there's disagreements. And you're the person that gets hurt the most if these people can't agree, right? So I rarely agreed to serve as co-guardian or co-agent. I would do it in specific situations. And those worked out well. Mostly the situations I've seen where there were co-people, it just did not work out, okay? So you want to avoid that. The situations where it tends to work out well is like a temporary situation where, like, let's say the daughter is agent under medical power of attorney and she's going out of town for 6 months or whatever. She could initiate a document that says, during the 6 months, there's going to be co-agents, or the principal could initiate this document saying, if there's ever a circumstance where my primary agent can't serve due to being out of town or whatever, then this person or this co-agent comes into play. Now, the requirement is that these two people still have to talk to each other and say, this is the decision at hand. Do we agree that this is what should be done? And that usually works out, okay? Provisions for successors. Again, this should be a checkoff list. Don't ignore this, because it may not mean anything today, but 10 years from now, it can mean everything when the person that you designated as that agent, for whatever reason, maybe they died, maybe they're unable to serve, maybe they're unwilling to serve, when they resign and you've got no backup in there. The reason that you want to have multiple successors is so that you have a backup plan, right? Because you never know what can happen to the first person that you appoint or the second person that you appoint. People die, they get divorced, they move 2,000 miles across country, they may move out of the country, they may get sick, right? Your agent under power of attorney may have more health problems than you do. And you don't want to have to redraft a document at that time because that first document that you drafted didn't work. Or if you have Alzheimer's or dementia and you don't have the mental capacity to draft the document, then you're going to court for a guardian or a conservator, right? So if you can at all have at least one successor, two if possible, in order of your preference, right? So it's kind of like the idea is that, if Mary, named first, can't serve, then John serves, and then if John can't serve, then Elizabeth serves, right? The other provision that you can put in there, which is a good one, right, is, and again, this is another backup, right? So if Mary, my first choice, and John, my second choice, can't serve for any reason, I give Mary, named first, the power to appoint an agent for me, or I give John, named second, the power to appoint an agent for me. This would really only be if you were incapacitated. So if you had Alzheimer's or dementia and you couldn't make any choices, right? You at least allow these people to appoint a successor for you. Again, the goal is to avoid having no one to serve for you. All right, so it becomes important the larger the number on your birth certificate, right? So let's talk about who can and who can't have information. There's a medical document called HIPAA. It's a Privacy Act, right? So regardless of whether you have these power of attorney documents, you can say, you know, doctor, you can talk to my spouse or you can talk to my kids or whatever. But it's an important provision that's in medical power of attorney. And it can also apply to financial power of attorney, especially if there are known family members who are going to cause issues or who are going to contest information. You can write a provision in there to protect your agent, right? To protect the fiduciary that you appoint. So I'll give you a couple stories. I had clients who knew that their family members would cause problems. So they wrote in these documents that under no circumstances is my agent or anyone to provide any medical information about me to my sister or even about my death. I don't want that, okay? And under no circumstances can anybody else make medical decisions. The other provision was in a will, and it said, you know, if my family contests this will, they pay all the legal fees. And the most that they can get out of my will, if they win, is $1. So basically, you're trying to prevent problems that you know are going to happen so that the agent or the fiduciary you appoint is not having to go through a living nightmare when they are acting for you, right? Now, while these extra provisions may not be legal in all states, you're going to have to ask, right? Sometimes if you just put the wording in the document, even though it's not possible, it may be enough to stop other people, right, from causing problems. So it would at least allow the fiduciary to tell the family that, hey, you know what, there's this provision in the will, and I can cut out the paragraph and show you that says this is what's going to happen. So if you really want to fight, here's the fight, and here's what's going to happen. You're going to pay the legal fees. At most, you're going to get $1. Your sister doesn't want you to have access to this information. Nobody's going to give it to you, okay? Same thing applies to the money side. You know, I've had children who wanted to change wills and who actually did because this provision wasn't in there, okay? So these days, especially on the financial side, more and more attorneys are doing video signings of wills. Because what happened with one of my clients was, even though there were two witnesses, right? Myself and the financial person who witnessed him signing it, and he was very clearly knew he picked 5 charities, right? His nephew, who was most interested in his estate because it was large, contested the will. And 4 of those charities didn't want to pay the legal fees to fight the will, right? They're like, just let him have the money, right? One did, and that one won. And it was a nightmare because we didn't record this on video. And most of the time, the charities are just not going to fight. But this man would have hated for his nephew to receive all that money. That was not his intention. And they didn't even get along, right? So these kinds of crazy situations happen all the time. Will contests happen all the time. So if you are an agent who needs help of any kind, there are usually in wills provisions for assistance or support or care management or CPAs or anybody, right? So it's another protection that can be included for your agent if that family member lacks a lot of experience doing this. You know, you think they're a good person, they're going to be responsible, but they don't know anything about medical care, or they don't know anything about investing money or any of that. It allows your agent to hire people to advise them, right? So it closes these gaps where, oh my gosh, what if you make the wrong decision and then you get called into court because you didn't know what you were doing, okay? Most professional fiduciaries know about this consultation ability. Most family members do not. So family members who are inexperienced wouldn't know who to consult. They wouldn't know what questions to ask. So make sure that you put these provisions in there so that you can ask professionals. You can hire a care manager to say, well, who could tell me about this? You could hire a CPA to say, hey, do you know a good financial advisor that I can just pay for advice? Okay. The other complication, and this is on the financial end, it's working with banks and financial institutions, which can be honestly a nightmare, but for a good reason, right? They're trying to make sure that nobody is coming in saying, well, I just got appointed the agent. I have access to all this money. I can do with it whatever I want. Because again, this happens. Family members steal money from their parents, from their spouses. happens way more than you would imagine, okay? So at the time you're appointed financial power of attorney, you want to take all these legal documents, these power of attorney documents, to go to all banks and all financial institutions. Some of them will send it to their legal department and it will be accepted. Others will say, we'll take this, but we have 3 other forms you got to fill out. And your principal needs to sign those forms. So if you do this right away and your principal is still a sound mind, everything goes through smoothly, because I can tell you, I've had banks refuse to accept my legal power of attorney because they needed an internal form signed. And it can be very difficult if you're, let's say you live 2,000 miles away from your principal, or if your principal's in a care community and they're wheelchair bound, you got to drag them to the bank to get this stuff notarized. Or you got to arrange for a notary to come to that place and you have to be there and the forms have to be signed. So it's just, you want to avoid the hassle factor that can happen later if you can take care of all of this right away. Okay. Then let's talk about all this new stuff, which is not always in most power of attorney documents. And there'll be a document again on the website page for this webinar about digital assets specifically that you can read. But think about this. How much information do you have stored in the cloud or on the internet? And what happens to all of this if you die? Do you have password lists? Does your agent have access to that password list? And in your medical or financial power of attorney, does your agent or your personal rep or your trustee have access to these accounts? Again, if you don't put all of that information about your digital assets in there, they're not going to have access. So think about, and this is one that comes up on Facebook a lot, right? What if you die? Is your Facebook account going to be there and every year your birthday is going to come up and people are going to keep wishing you happy birthday and they didn't know that you died? I've actually had that happen. So Facebook now has a provision that say, if I die, my husband can close my account, right? This is stuff that happens all the time because we didn't think about this, 5 years ago or 10 years ago, right? So depending on your work and your personal interests, assets that you own can be very electronically based and significant, and they can have a lot of value. Think about what if you have music collections or ebooks or computer programs or all of that. Again, this wasn't important 5 or 10 years ago. It's important now, and it's going to be more important as more of us store information digitally and on servers. You got to make sure that you've got password lists and access and all of that. So an attorney can add this provision for digital and virtual assets into your documents and give people permission to do this. So again, think of your iTunes account, your Amazon account, your Kindle account, Facebook, online bank accounts, your credit card, your health information, all of this. Because it's a problem if you don't give someone access to this in a written document. They can say, well, no access, sorry, right? So be sure to discuss this provision with your attorney. Let's talk about living wills. I've talked about this a little in other sections, but again, this is the add-on to your most post DNR and 5 wishes document, right? So here's other stuff that can come up. Let's say that you have a diagnosis of Alzheimer's and dementia, which totally changes your life situation. Now, we don't plan for this. It just happens, right? And sometimes people are diagnosed and, excuse me, they may see an old primary care physician who doesn't know how to diagnose memory loss, or the physician's afraid to say, hey, you know what, you have memory loss, you probably should go to a specialist to be diagnosed, because let's face it, who wants to be diagnosed with Alzheimer's or dementia? It truly is irreversible, and a lot of people see it as a death sentence, so they worry about it all the time, right? But how might this diagnosis change your wishes? So let me give you an example of how this can complicate a medical power of attorney, a living will, a DNR document. So let's say that you have your mom or dad and they constantly wander out of the house, but they can probably still live there a little longer if you have caregivers. Should you immediately just move this person up and lock them up in a memory care unit where they can't get out, right? Or is there a middle intervention where you have caregivers in the home mostly, right? Because even if you have a caregiver, somebody can walk out in the middle of the night. So might a better option be like a GPS watch tracker or a GPS soul now that can track the location? So like you're there and You see mom in 10 minutes, and in 15 minutes, she's like gone and out of the house, and you're like, holy moly, where'd she go? You can look at this tracking advice and you can go find her. Or you can call the police and they can go find her, right? So use of these monitoring devices, though, relates to individuals' right to privacy, just like having cameras in the home, right? Well, I have a right to privacy, which means you can't put a tracking device on me. So the court or doctors or somebody could argue with you and say, you know what? They have a right to privacy. You can't, I know you think that's going to help them stay at home, but you don't have the right to put it on there. Your sibling could argue with that. People could argue about cameras and all that kind of stuff. So again, this right to privacy or right to patients' rights comes up a lot. So you could put a provision again in your documents that say, hey, you know what? I realize I have a right to privacy or patient privacy, but my agent has a right to decide on these if some unusual circumstance comes up where I have Alzheimer's and I need a tracking device, or cameras need to be put in my home to supervise caregivers. And there's all these things that can happen that come up. The other thing is people with Alzheimer's sometimes lose the ability to lift a fork to their mouth, okay, but they're still pretty healthy. Would you want somebody to feed you? If you had a caregiver, would you want them to feed you breakfast and lunch and dinner as long as you were doing well or not, okay? So it's the difference between, yes, I want, quote, artificial nutrition where somebody's feeding me, not a feeding tube, not any kind of tubes in my body, but somebody's going to lift a fork to my mouth, right? There's all these things that you can't even imagine that are going to come up. So you got to put as many provisions in there as possible. Then, kind of like the family disputes we talked about before, where if you can identify these situations early when you're drafting these documents in that what would you want when conversation, right? You can put provisions in there for who gets information, who doesn't get information, who can make decisions, what happens if it goes to court, all of that. I wish I could tell you that all of these circumstances are rare, but because I've had so many experiences, to me, they're not rare. So they happen. And so I feel like you should know about these surprises and you should be prepared, because this potential for family conflict or conflict with medical providers, it happens. And it really depends on what you put in the documents and how much power you give your fiduciary, their willingness and comfort level to advocate against a faulty medical system or a bank or somebody else who says, you know what, you can't do this. But the document says, oh, yes, I can. And this is what they want, and I'm going to do it. So I can't tell you how many times I've heard from doctors, oh, they're old, just let them die. Don't do the procedure. And my response is always, well, that may be your choice, but I have this document and I know what my person wants. I'm the agent. I'm the guardian. I'm the conservator. This is what we're going to do because it's legally in papers. Now, I can tell you that even though you may have information in legal papers, doctors will still go against you. Another quick story. I had a client, power of attorney. He had heart problems for years, and the cardiologist said, you know what, putting a pacemaker in is not going to make any difference. It's not going to give him quality of life, and it's not going to extend his quality of life. Well, unfortunately, he got sick and he went to the emergency room. And the emergency room doctor's like, we need to put in a pacemaker. And I'm like, no, you don't. Here's something from his other doctor that says it's not going to work. Well, the doctor asked my client, and the client's like, yeah, I guess I want the pacemaker. So that was assumed to be patient consent, right? And my client at that point had a little bit of memory loss. And so I could have taken it to an ethics committee, which would have involved a lot of time and a lot of crazy effort. And so I didn't fight it, right? They put in the pacemaker. So not realizing that he lived in an assisted living community, and how was he going to get to all of these follow-up pacemaker appointments? Well, so they put in the pacemaker and he went home, and about a week later, he just didn't wake up in the morning. He died because, of course, the first doctor said a pacemaker is not going to save his heart. It's not going to prolong his life. So what happened was all these medical professionals did what they thought best. They made a lot of money off of it, and the person died anyway. So why put someone through that if it's unnecessary? So sometimes you have to fight. Sometimes fighting isn't going to make a difference. And that is where you as that fiduciary has to make that decision. So last in this topic is just document mobility. Topic short and sweet. It's very simple. Laws and statutes differ by state to state. If you move, advise the attorney in the state from which you're moving. Ask for a recommendation to another state. See if there's any glitches in the two documents, and if there is, just have an addendum put on there. So the intention of this video was just not to scare you, but just to make you understand that there are a lot of things that can go wrong that relate to situations that involve power of attorney. What you want to do is make it easy for your agent to act. And a lot of the topics that we've discussed in this webinar will allow you to do that. I'm Pamela D Wilson. I'm a caregiving expert, advocate, speaker, 20 years experience. I have served in all of these roles that I'm sharing with you. Please like this video, like my YouTube channel, follow it, and please comment, because commenting allows other people to more easily find this video. You're actually helping other people through your actions. You can follow me here. Also go over to my website, PamelaDWilson.com. That is where you'll find the link to this online webinar with all the documents that I have mentioned. You can also request a private consultation with me by going to the contact form and completing that. I thank you so much for being here. I know this was a long webinar, but hopefully a valuable webinar. And I'll see you all again soon in another video.